2 weeks before my 30th birthday, my own sister stood in a Cook County courtroom and asked a judge to declare me too mentally unstable to control my own money. She spoke softly, the way a frightened older sister might, like someone who had spent years quietly protecting me from myself. She told the judge I could not hold down a steady job. She said I believed people were stealing from me. She said if I were allowed to receive $3.2 million, it would put me in real danger. Beside her, our mother cried into a tissue and nodded after every single accusation. She told the court that I had changed after our father died, and that my sister was the only one responsible enough to manage what he had left behind. I did not interrupt either of them. I did not raise my voice. I did not defend myself, not even when their lawyer stood up and called me paranoid, unstable, and financially reckless in front of a room full of strangers. Across the aisle, my sister rested one hand on the folder holding her guardianship petition. She looked at me the way someone looks at a person they've already beaten. Calm, certain, like the money was already hers. What she did not know was that a sealed file had reached the judge that same morning. It held records she had never seen, papers she believed no longer existed, and one fact about my life that my own family had laughed off for years without ever once checking if it was true. The judge read through several pages in complete silence. Then she took off her glasses, looked straight at my sister, and asked a single question. "Do you actually know who your sister is?" Our mother stopped crying. My sister opened her mouth to answer, and nothing came out. Watching from where? Please comment. My name is Claire Hartley, and before I tell you what happened in that courtroom, you should understand exactly what was waiting for me on my 30th birthday, and exactly how far my family was willing to go to take it from me. My father, Gerald Hartley, built Hartley Medical Logistics out of a rented warehouse into one of the most respected medical supply companies in the Chicago suburbs. He was never flashy. He drove the same dark blue sedan for 12 years, packed his own lunch every morning, and could still remember the names of warehouse workers he hadn't seen in months. My older sister, Renata, was nothing like him. She loved expensive restaurants, private investor dinners, and being the most important person in whatever room she walked into. After business school, she moved to Orange County and started Silvercrest Ventures, an investment fund built around wellness technology companies. Our mother, Eleanor, treated every glossy magazine feature about Renata like proof that one daughter had inherited our father's ambition, while the other had inherited his habit of hiding behind spreadsheets. That second daughter was me. I worked remotely for a risk advisory firm based in downtown Chicago, examining payment records and digital accounting systems for companies that suspected fraud. My contracts required confidentiality, so I rarely explained the details, even to family. Renata described my career to relatives as freelance bookkeeping and told people I spent my days inventing problems in other people's invoices. I let her believe that because correcting her had never once changed how she treated me. 4 years before that courtroom hearing, our father died of a massive stroke while attending a supplier conference in Milwaukee. There was no mystery to it, no secret confession, no dramatic warning beforehand. What he left behind was a carefully built trust. Renata received control of the operating company. I was named beneficiary of a separate trust, funded through life insurance and the sale of several personal investments, worth roughly $3.2 million, to be released to me when I turned 30. In a letter he left behind, he explained his reasoning plainly. Renata had already been given opportunities through the company. He wanted me to have the freedom to build something that was entirely my own. Renata called the arrangement unfair, though she never tried to challenge it, because doing so would have meant admitting she had already received far more than I had. For a few years, nothing happened. Then Renata moved back from California and took over as Chief Financial Officer of Hartley Medical Logistics. She told everyone that Silvercrest Ventures was expanding into the Midwest, but the truth was that several of her investments had already failed. 2 health tracking startups had collapsed. A luxury recovery retreat had defaulted on its loans. Investors who once praised her instincts were now demanding their money back. Instead of admitting any of it, Renata began quietly moving company money through 3 consulting firms registered in California. Those firms submitted invoices to Hartley Medical Logistics for strategy work, vendor development, and market analysis. In reality, they delivered almost nothing. Money left our father's company, passed through those firms, and flowed straight back into accounts tied to Silvercrest Ventures. By the time the company prepared for its annual audit, the shortfall had grown to nearly $1.8 million. Renata needed cash, fast, before any auditor looked closely at those vendor files. My trust was the easiest target she could see. 9 months before my birthday, the bank overseeing my trust received a document claiming to give Renata authority to advise on managing my inheritance if I ever became mentally incapable. The bank refused it outright. The signature looked copied. The dates did not line up with their own records, and there was no certificate from the electronic signing service the document claimed to have used. Instead of backing off, Renata changed course entirely. She started asking pointed questions about my health. Had I seen a therapist after Dad died? Was I still on anything for anxiety? Why had I switched consulting assignments twice in 1 year? Did I ever feel like people were watching me? At first, I thought she was genuinely trying to reconnect. Our mother joined those conversations too, encouraging me to be open and honest. So I was. I told them I'd had panic attacks after Dad's death. I told them therapy had helped enormously. I admitted that working in fraud investigation sometimes made me suspicious of patterns other people would never notice. Every honest answer I gave became a sentence they could later strip of context. Renata told relatives I was obsessed with imaginary crimes. She told family friends I couldn't hold a job. She pointed to my quiet apartment in Northbrook as proof I was isolating myself from everyone who loved me. Our mother backed her completely because Renata was the one paying the property taxes, insurance, and upkeep on the large house she lived in. If Renata lost the company, our mother believed she would lose everything too. I still didn't understand how far they were prepared to go, not until 6 weeks before my birthday, when a process server handed me a petition asking the court to declare me disabled and appoint my sister as guardian of my entire estate. They hadn't been checking on me all those months. They had been building a case. The petition arrived at 8:15 on a Monday morning, 10 minutes before I was scheduled to lead a video meeting with a hospital network in Ohio. It described me as unemployed, emotionally unstable, financially reckless, and consumed by delusions that family members were stealing from me. Attached to it was a psychological evaluation written by a Dr. Martin Reyes. I had met him exactly once, on a video call my mother had framed as a family wellness session. It lasted 52 minutes. He barely asked about my income, my bills, my work, or the fact that I had lived completely independently for 11 years. Instead, he kept circling back to whether I distrusted Renata and whether I believed she was hiding money. At the time, I assumed he was there to help us communicate better. In his written report, he described my answers as possible persistent delusional thinking and suggested that receiving a large inheritance could place me at serious risk of exploitation or impulsive behavior. The court didn't hand Renata control right away. It did, however, issue a temporary order freezing the trust company from releasing my $3.2 million until a full hearing could take place. My regular salary account stayed open, but the damage started almost immediately. Renata sent copies of the petition to 2 relatives who forwarded it on to others. Someone contacted one of my clients directly and claimed I was under investigation for mental incompetence. That client suspended my contract while their legal team reviewed the situation. I had enough savings to survive for a while, but between legal fees, expert witnesses, and lost income, that cushion wasn't going to last forever. I moved temporarily into the guest room of my closest friend in Naperville because Renata had started showing up outside my apartment unannounced. She would knock, wait for me to refuse to open the door, then text our mother that I was shutting the family out. Every reaction I had was being turned into evidence against me. That was when I hired Vivian Cross. Vivian specialized in contested trusts, fiduciary abuse, and adult guardianship cases. We had crossed paths years earlier when my firm assisted one of her clients in a corporate embezzlement dispute. She didn't promise me an easy win. She set the petition down on her desk and told me plainly that Renata had built a powerful emotional story. A grieving younger sister who had grown suspicious and withdrawn. A concerned older sister trying to protect her. A frightened mother who agreed. A doctor who backed them all up. Vivian said we couldn't beat that story by matching their emotion with our own. We had to replace it, piece by piece, with verifiable fact. First, we went after the trust amendment. A digital forensics specialist pulled the file's metadata and found it had been created 3 months after our father died. The listed author wasn't his estate attorney. It was a user account tied to Renata's former California office. An earlier saved version of the same file was labeled Claire Control Draft. The signature on the document had been lifted from an old vendor agreement our father had signed years earlier, then copied, resized, and pasted into the new one. The file claimed to have been completed through an electronic signing platform, but there was no audit trail or transaction record from that platform anywhere. Second, we followed the money. Vivian subpoenaed records connected to the companies that had been invoicing Hartley Medical Logistics. All 3 consulting businesses shared the same private mailbox in Irvine. Their phone numbers all forwarded to the same answering service. Payments moved out of our family's company, through those 3 firms, and into accounts controlled by Silvercrest Ventures, often split into amounts just small enough to slip under internal review thresholds. Together, those transfers accounted for the full $1.8 million shortfall Renata was trying to hide. Third, we looked closely at Dr. Reyes's evaluation. The invoice for his assessment hadn't been paid by our mother, as Renata had claimed. It had been paid by one of the California consulting firms. The file properties showed his first draft report had been written before he ever interviewed me. An email from Renata's assistant had asked him specifically to include the phrase, persistent delusional thinking, because it would help support emergency financial protection. He had reached his conclusion before he ever asked me a single question. The most important witness turned out to be Owen Marsh, the former controller of Hartley Medical Logistics. Owen had worked alongside our father for 17 years. He'd noticed the consulting invoices early on and asked Renata to provide contracts proving the work was real. She accused him of resisting modernization and fired him 2 weeks later. He'd kept copies of the approval logs, believing they would eventually surface in an audit. Those logs showed Renata had personally signed off on every one of the suspicious payments. Owen agreed to testify, though he warned me Renata would attack his credibility and paint him as a bitter former employee. Vivian told him that was exactly what she expected. Then our mother made a mistake Renata couldn't explain away. She called me late one night while I was still staying in Naperville. I didn't answer because Vivian had told me to keep all communication through her office. My mother left a voicemail instead. She begged me to stop fighting the guardianship. She said Renata only needed temporary control of the trust until the audit was finished. She said if I refused, the company could collapse and the house could be taken from her. Then quieter, she said that once the missing money was replaced, everything could go back to normal. I listened to that message 3 times. Up until that moment, I had wanted to believe my mother was just repeating lies she didn't fully understand. That voicemail proved she knew exactly what the guardianship was really about. What I still didn't know was whether Renata had told her the whole truth, or only enough to keep her afraid. By the morning of the hearing, Renata had transformed herself into the picture of a patient, exhausted older sister. She wore a plain navy dress, no visible jewelry except our father's old watch, almost no makeup. She sat close to our mother and kept one hand over hers whenever the room went quiet. Her attorney, Bradley Simmons, opened by saying this case had nothing to do with punishment or money or family conflict. He said it was purely about protection. He described me as a talented but troubled woman whose condition had worsened after our father's death, someone who could no longer tell the difference between professional concern and personal suspicion. He said I drifted between jobs, pulled away from friends, accused my own sister of fraud, and refused help from the people who loved me most. He never once mentioned that my jobs were confidential consulting assignments. He never mentioned that I paid my own rent, my own taxes, my own insurance, and my own student loans. He never mentioned that every financial irregularity I had ever raised was backed by actual bank records. Renata testified first. Her voice trembled at exactly the right moments. She said she didn't even want my inheritance and would happily see it placed under professional management. She claimed the guardianship was necessary because I had become vulnerable to scammers and imagined threats. When Vivian asked whether she had attempted to submit a trust amendment naming herself as my financial advisor, Renata said she believed our father had prepared it himself before he died. When Vivian asked who had actually sent that file to the bank, Renata said an assistant handled all estate correspondence. She couldn't recall which assistant. Our mother testified next. Eleanor began crying before Bradley had even finished his first question. She told the judge I had changed after Dad died, that I'd stopped coming to family dinners and become fixated on the idea that Renata was stealing from us. That part, at least, was technically true. I had stopped going to those dinners after Renata began asking detailed questions about my therapy sessions and the exact date my trust would be released. My mother told the court Renata had held the family together, supported her financially, and tried everything she could to help me. She called signing the affidavit against me the hardest decision of her life. Vivian asked if I had ever missed a mortgage payment. I didn't have a mortgage. She asked if I had ever been evicted, declared bankruptcy, lost money gambling, or wired funds to strangers. The answer to every question was no. Then Vivian asked whether our mother depended on Renata to cover the expenses on her house. Bradley objected, but the judge allowed it. My mother admitted that she did. Dr. Reyes testified after her. He spoke confidently about anxiety, fixed beliefs, impaired judgment, and the risks that come with sudden wealth. He pointed to my suspicion that Renata had been moving company money as evidence that I interpreted ordinary events as personal threats. Vivian asked how long he had actually evaluated me for. 52 minutes. She asked if he had reviewed my bank statements. No. My tax returns? No. My employment records? No. My medical history from my own treating therapist? No. She asked if he had spoken with anyone at my company. He said confidentiality prevented it, though he had never once asked my permission to do so. She asked if he knew I handled complex financial investigations for major corporate clients. He said he had been told I did occasional bookkeeping work. Vivian let that answer hang in the air without responding. The court-appointed evaluator spoke next. She had visited my apartment, reviewed my monthly expenses, spoken with my employer, and tested my understanding of the trust. She found no evidence I was unable to manage money or make my own decisions. She noted that I was anxious about the case itself, but said anxiety during litigation was not proof of disability. Renata's expression tightened, but Bradley argued the evaluator hadn't addressed my alleged delusions about the family company. He said the court still needed to consider that my intelligence might simply allow me to hide a serious condition well. For a few minutes, it looked like the whole case might come down to a battle between competing experts. Then I saw Renata lean toward our mother and write something on a legal pad. I could just make out the words Silvercrest and transfer schedule. She was already planning what to do with my trust. Vivian saw it too. She closed her folder and didn't ask another question. The judge then requested the sealed materials that had been delivered by my employer and the trust company. A clerk carried the file up to the bench. Renata watched with mild curiosity. Bradley looked confused, since he had only ever received a summary under the protective order. The judge read through it in complete silence for nearly 3 minutes. No one in the room moved. Then she took off her glasses and looked directly at my sister. Renata straightened in her seat, expecting to be asked whether she was prepared to serve as guardian. Instead, the judge asked the question that unraveled the entire identity my family had spent a year building around me. "Ms. Hartley," she said, "do you actually know who your sister is or what she does for a living?" Renata gave a small, uncertain laugh. She said I worked irregular online jobs and had exaggerated my responsibilities for years. The judge asked me to stand and state my full name, age, employer, and occupation for the record. I rose slowly. "My name is Claire Hartley. I am 29 years old. I am a lead fraud data analyst for Bellwood Risk Advisory in Chicago, and I am a certified fraud examiner." Renata stared at me like I'd started speaking a language she didn't recognize. I explained that my work involved tracing fraudulent payments, reconstructing altered accounting records, identifying shell vendors, and preparing reports for attorneys, insurers, and regulatory agencies. I had worked for the same firm continuously for 5 years. What Renata called job instability was simply separate client assignments. My income had grown every single year. I had never been fired, disciplined, or found incapable of handling confidential financial work. The sealed file contained my employment verification, my tax records, my performance reviews, and a declaration from my own managing director. It also confirmed I had been assisting outside counsel on a confidential investigation into a network of vendor payments. I wasn't a federal agent. There was no badge, no secret identity, no dramatic undercover assignment. I was simply very good at finding out where money went after someone tried to hide it. The judge told Renata that the person she had described as financially incompetent was professionally responsible for analyzing transactions worth hundreds of millions of dollars. Renata recovered quickly, insisting intelligence didn't prevent mental illness, and accused me of using my job to feed obsessive suspicions. The judge agreed that a successful career alone didn't settle the case. Then she opened a second folder. She held up the trust amendment Renata had submitted to the bank. "If your sister invented this problem," the judge asked, "why does this document, bearing your father's signature, have a creation date 3 months after his death?" Bradley turned toward Renata so sharply his chair scraped the floor. He told her not to answer another word until they had spoken privately. Our mother stopped crying entirely. All the color drained from her face. Renata claimed she'd never seen the metadata and that some estate assistant must have prepared the file. The judge asked for that assistant's name. Renata couldn't provide one. The judge then asked why an earlier draft of that same document had been saved under the title Claire Control Draft on an account linked to Renata's California office. For the first time all day, Renata had no story ready. Bradley requested a recess. The judge granted 15 minutes but ordered everyone to remain on the floor. Out in the hallway, Bradley pulled Renata away from our mother and spoke to her in a low, furious voice. Our mother looked at me like she was seeing a stranger for the first time. She asked why I had never told her what I really did for a living. I told her she had never once asked. She had accepted Renata's version of me because it was simply easier. Vivian stepped beside me and warned that the forged trust document was only the beginning. Proving it was false would end the guardianship case. Proving why Renata had created it would expose everything else underneath it. When the courtroom doors opened again, Renata's confidence was gone, but the evidence still waiting inside was far worse than she realized. Vivian began with the digital forensics specialist. He explained how every electronic file carries hidden information about when it was created, who edited it, and what software produced it. The trust amendment had been created 96 days after our father's death. The listed author matched a user account assigned to Renata. The signature image had been copied directly from an old vendor contract and inserted into the new document. The file had been edited repeatedly from an internet address tied to her former Newport Beach office. Bradley tried to suggest another employee could have used her account. The specialist then produced a device log showing the final version had been approved from Renata's own personal laptop using her fingerprint. Owen Marsh testified next. He described his 17 years as controller at Hartley Medical Logistics and his responsibility for reviewing every large vendor payment. He explained that the 3 California consulting firms had no project files, no completed work, and no employees he could ever identify. When he questioned the invoices, Renata instructed him to approve them as executive expenses. He refused. 2 weeks later, she fired him. Owen produced the approval logs showing Renata had personally authorized every single transfer. He also produced an email in which she'd written that Claire's trust would fix the gap before the annual review. Bradley argued the phrase could refer to a legitimate investment opportunity. Owen replied that a private beneficiary's trust could not legally be used to cover company losses unless that beneficiary chose to invest it voluntarily. I had never agreed to invest a single dollar. Vivian then displayed a full timeline of the transfers. Money left Hartley Medical Logistics, passed through the consulting companies, and landed back inside Silvercrest Ventures. Some of it covered investor withdrawals. Some paid the lease on Renata's California residence. Some paid for a luxury vehicle registered through one of the shell companies. The total came to $1.8 million. Renata claimed the transfers were temporary loans between companies. There were no loan agreements, no repayment schedules, no board approvals, and no disclosures to the company's minority shareholders anywhere in the records. Dr. Reyes came next. Vivian showed him the invoice for his evaluation. He confirmed his standard fee for a single psychological assessment was far lower than the $18,000 actually charged. That payment had come from Crestline Consulting, one of the same California entities from Owen's records. Dr. Reyes said he didn't know who controlled that company. Vivian then displayed an email from Renata's assistant thanking him for helping protect the family's assets. Attached to that email was a draft of his report, written 2 full days before he ever interviewed me. That draft already contained the phrase persistent delusional thinking. Vivian asked how he had reached a diagnostic conclusion before speaking to me even once. He said the draft was only a template. She asked why a template happened to include my name, my father's death, my inheritance amount, and an accusation that I imagined financial fraud. His answers grew slower and quieter. The judge asked whether he had disclosed the payment arrangement to me or to the court-appointed evaluator. He admitted he had not. When Vivian asked whether Renata had specifically requested language supporting guardianship, Bradley objected, but Dr. Reyes answered before the judge could rule. He said Renata had told him the family needed strong, decisive language because I was about to receive dangerous amounts of wealth. The judge ended his testimony there and ordered the transcript and every document forwarded to his professional licensing board. Our mother was called back to the stand. Vivian played the voicemail Eleanor had left me. Her own voice filled the courtroom, pleading with me to stop resisting because Renata only needed temporary access to the trust until the audit passed. When the recording ended, Eleanor covered her mouth with both hands. Vivian asked what missing money she had been referring to. Eleanor said Renata had told her the company had a short-term cash problem. Vivian asked whether she'd known the affidavit she'd signed claimed I couldn't pay my own bills or understand financial documents. Eleanor admitted she knew I had always handled my own expenses. She said Renata had warned her that without the money, the business would fail and the bank would take the house. Then Vivian asked the question I had been dreading. "Did you believe your daughter's freedom should be traded for your house?" Eleanor began crying again, but this time the tears didn't help her. She said she'd thought the guardianship would only last a few months. She'd thought I would eventually forgive them. I realized in that moment my mother hadn't been entirely deceived after all. Renata had manipulated her fear, yes, but Eleanor had still chosen comfort over me. Judge Patricia Voss took a short recess to review everything. When she returned, she ruled from the bench. The petitioners had failed to prove, by clear and convincing evidence, that I lacked the capacity to manage my own estate. In fact, the evidence showed the petition itself had been used as a tool to seize control of my trust. She dismissed the guardianship petition entirely, lifted the temporary restriction on the trust, and ordered the trust company to preserve every related record. She referred the suspected forgery, false affidavits, and financial transactions directly to state and federal authorities. Bradley asked permission to withdraw as Renata's attorney, stating that what had come out in court created an ethical conflict he couldn't ignore. Renata stood up and shouted that everyone was twisting ordinary business decisions into crimes. The judge ordered her to sit down. She refused, until a deputy stepped closer. Outside the courtroom, 2 federal agents and an assistant United States attorney were already waiting. It turned out a separate criminal investigation into the California vendor network had been developing for months. My own analysis had helped outside counsel identify the pattern early on. But Renata's forged trust document and sworn courtroom testimony had handed them even more evidence of intent. A federal indictment had been unsealed during the recess. The agents arrested her on charges connected to wire fraud, falsified records, and unlawful diversion of company funds. Our mother stood frozen against the wall, gripping the court papers with both hands. As an agent secured the handcuffs, Renata looked straight at me. "You destroyed everything Dad built," she shouted. I shook my head. "No, you gambled it away. Then you tried to erase me so no one would ever see what you'd done." She demanded that our mother call someone, fix something, tell the agents they were making a mistake. Eleanor didn't move. Renata had spent nearly a year trying to prove I couldn't be trusted with money. By the end of that single day, she was the one who had to explain where every missing dollar had gone. The criminal case dragged on for 18 months. Renata fought the charges at first, insisting the transfers were legitimate business loans and that the trust amendment had been prepared by some unknown employee. That defense collapsed the moment prosecutors recovered deleted messages from her personal laptop. In one message, she told her assistant that once the court gave her control, she could quietly move the trust money into a family preservation account and repay everything before anyone noticed. In another, she called my anxiety history the cleanest route to control. Facing overwhelming evidence, she eventually accepted a plea agreement. She received 9 years in federal prison and was ordered to pay restitution to Hartley Medical Logistics, its minority shareholders, and several investors who had been misled about Silvercrest Ventures. Her California property, investment accounts, and luxury vehicle were all sold or seized. She was permanently barred from serving as a financial officer or raising investor money ever again. For Renata, the worst part was never losing the expensive life she'd built. It was losing control of the story. The public record now showed that the sister she'd called unstable had identified the fraud correctly the whole time, while the successful executive had forged documents and weaponized the court system to hide her own losses. Our mother wasn't treated as an innocent bystander either. She admitted to signing statements she knew were false and helping Renata pressure me into surrendering control of my trust. Because she'd cooperated with investigators and hadn't personally received any of the stolen business funds, she avoided prison. She received 6 months of home confinement, 3 years of probation, and a restitution obligation of her own. She eventually had to sell the Northbrook house, since she could no longer afford it without Renata's help. For months afterward, she mailed me letters through Vivian's office. Some were apologies. Others tried to explain how frightened she'd been of losing the company, the house, the only life she knew. I eventually answered one of them. I told her that fear could explain a choice, but it couldn't erase the harm that choice had caused. I wasn't ready to rebuild our relationship, and I wasn't going to accept guilt as a substitute for real accountability. We began exchanging occasional letters after that, but I kept firm boundaries in place. Forgiveness, I learned, doesn't require handing someone immediate access back into your life. Dr. Reyes faced a full professional investigation. His license was suspended, and he entered a civil settlement tied to the misleading evaluation. Part of that settlement now funds legal services for people whose mental health history has been misused in family financial disputes. That mattered to me deeply, because I never wanted my story to suggest that anxiety, depression, therapy, or medication made a person weak or unreliable. I had experienced panic attacks. I had needed real help. Neither of those things ever made me incapable of managing my own life. Mental health treatment should protect a person's dignity. It should never become a weapon used to strip away their rights. When the trust was finally released, the full amount came out to slightly more than $3.2 million, thanks to investment growth over the years. I didn't quit my job, buy a mansion, or spend it all just to prove I'd won. I hired an independent fiduciary advisor with no connection whatsoever to my family. I built a long-term financial plan, paid off my legal expenses, and invested the rest conservatively. Then I used part of the inheritance to start the Hartley Financial Autonomy Project. The program partners with community centers and legal aid organizations to help people recognize financial abuse happening inside their own families. We teach participants how to keep secure copies of wills, trusts, beneficiary forms, and powers of attorney. We explain why no one should ever sign an affidavit or financial document under emotional pressure. We show people how to review account alerts, preserve emails, request independent professional advice, and choose lawyers, doctors, and accountants free of hidden conflicts of interest. We also remind everyone that instinct can be an important warning sign, but serious accusations still need to be backed by records, qualified experts, and lawful evidence. The goal was never to make people suspicious of every relative in their life. It was to help them understand that love without accountability can quietly turn into control. My own work changed too. I'm still a fraud analyst, but I stopped taking on every difficult case just to prove I could handle it. I travel more now. I spend time with friends who actually respect my boundaries. I've learned to build a family out of trust, not just out of blood. At the very first workshop funded by the program, I watched an elderly woman place copies of her estate documents into a secure folder for the first time. A young man asked how to protect his parent from a relative pressuring them to change their beneficiaries. Another woman quietly admitted her brother had been using her depression diagnosis to control her bank account. That's when I understood that the inheritance was never the most important thing I got back. What I recovered was the right to define myself on my own terms. The lesson from all of this is simple. No one should ever be allowed to turn a mental health struggle into proof that you don't deserve your own independence. Keep records, ask questions, seek out professionals who have no financial stake in the outcome. Never let shame keep you from asking for help. And remember, standing up for the truth is not the same thing as destroying a family. Sometimes the family was already being destroyed by secrecy, greed, and fear long before you said a word. Telling the truth just makes the damage visible. What would you have done if the people trying to take away your freedom were the very same people claiming they only wanted to protect you?